11.
Your Lordship, I appear for the petition.
My Lordship, we requesting for next week, my Lordship.
We'll keep it after a little while. So we'll just keep it after 3 weeks so that we'll finish now.
Your Lordship, it pertains to reservation for the
I know.
IPS. The UPSC mains would be this week. After that, the form would have to be filled. If we could have it anytime earliest convenient to your Lordships.
Can it come after 2 weeks?
Your Lordship.
All right.
Well, that's the West Bengal matter.
West Bengal, after the income tax group, we'll start the West Bengal today. Let's see how long the income tax group is taking, or we'll then continue on Thursday or something like that. Will it be okay for everybody if we take it on Thursday?
But it may be abortive because nobody has filed a chart, nobody has filed a counter, more matters have come, your Lordship may have an incomplete matter. And Lordship may start the matter.
If it is kept back by.
The Lordship gives a procedural direction to
Yeah.
complete the pleadings and have the chart which the government was to give your Lordships, then my Lordship, it will be
No
better to
counter
take.
has been filed by the...
No.
One or two have been filed.
Who's appearing for the respondent?
Detailed order.
We are appearing for the.
You have not filed a counter? You want to go on with the...
Not get the every copy, and not only that, School Service Commission is also not filed anymore. Because last occasion.
You are appearing for whom?
I am appearing for the writ petition.
The original writ petitioner before the High Court. And who are the other respondents in these?
School Service answering respondent is the School Service Commission is the answering respondent. And they also, I in the last occasion, remember, they says that the segregation list they are going to file, but till that whether they are not filed.
You have a copy of whatever it files, the state government or the.
Where is the School Service Commission?
Just one. State has filed an LLP number one.
Application
for.
The state and commission are not filing any further affidavit, so it is for them to respond to the SLP.
Are you people filing your counters to the SLP or not? All right, we will give one opportunity so that nobody says we didn't give that opportunity.
Clear.
Yeah, we'll say that,
But state and commission also filed the SLP here. They have preferred the special petitions there.
yes.
Therefore, when they are asking for the affidavits, their stand is very clear in the SLP itself.
But the private writ petitioners before the High Court.
Private, they have not filed with it. They are the writ petitions before the High Court.
So what we'll do is that we will give them an opportunity to file a counter within 2 weeks.
Smart.
If they don't, we'll say the right to file the counter will stand closed. And we will say that, is it possible to prepare one compilation? Otherwise, it will be impossible, with so many lawyers appearing.
Nodal council this side nodal council, that side, no kind of.
May I just tell you one thing?
I think
Lord,
the commission will.
in Calcutta High Court, there are 50 petitions. 50 petitions. Now, just one, that what has happened, Lord, in one affidavit, in one petition, one affidavit, another petition, another affidavit, one petition and one report, another report is another affidavit. All, Lord, it is really, Lord, I can try to do it, Lord, but it's really difficult, Lord.
Better if
Any
commission
report
does
is
it.
not.
The commission is more concerned, so commission should file the.
No, we are not, the commission is not concerned. Lord, we are.
All right, you tell us who will really
One
help
nodal
in.
council each side,
Lord,
nominate.
Your Lordships, may I suggest a
Lord, we are looking.
I think.
Lord, we are looking to these things to
Your
that
Lordships, may
commission,
I make a suggestion?
commission is
With
changing,
regards to housekeeping here.
Lord, commission is changing their stand from time to time, Lord. This has created a great difficulties to us. Commission in Supreme Court said something else.
Now, you are appearing for whom?
Lord, I am appearing for the OMR disputed candidates. Group C, Group D, Class 9, Class 10.
So you are the candidates who will be displaced now as a result of the judgment.
Exactly.
So really speaking, you are the same side as this.
May I just point
person.
out, Your Lordships, there will be 5 categories of people. The first will be, Your Lordships, the government. The second will be SSC.
1 second. Yes.
One is government, second is SSC.
Yes.
Third are the original writ petitioners whose grievance was that they were not selected due to all the malpractices that were followed. That will be class 9 and 10, class 11 and 12, and group C and group D. All the 4 categories subsumed in that. And group C and D. The 4th category, your lordships, will be
Yes.
people who were appointed and their appointments were cancelled. Yes, your lordships. And 5th will be the residual category who would have been appointed, but action yet not taken against them.
No.
And also, very well, also CBI, lastly. So these are the main stakeholders in the entire matter, your lordships, and I humbly submit that it cannot carry on in personam. This matter has to carry on in rem. So once these interests are before your lordships, represented before your lordships, rest of the people who want to file can file interventions. For example, today my petition is also a new SLP with a permission to file.
Now tell us this, who would be appearing for the government of West Bengal? Who is
I'm
leading the?
appearing for the government Bengal, and Astha Sharma will be the coordinating council from this side.
So whether your lordship, they are writ petitions or
Model
interventions or SLPs, the dispute is the same.
This is the main appeal, no?
Well, it's also in 12.27, we moved an application for.
Apart from that,
The name of the commission is West Bengal Central School Service Commission.
Full circumstances.
Right. Now, who's appearing for the School Service Commission?
Mr. Jaideep Gupta was in it.
Mr. Jaideep Gupta.
Your lordships, now SSC can file a common affidavit.
Yes, fair enough. Mr.
For
Gupta,
everyone.
you are appearing for the School Service Commission? All right, perfect. Now, the petitioners in the High Court who are not selected,
We are appearing for the, on behalf of the writ petitioner. Apart from this, all, my lord, West Bengal Board of Secondary.
so you are those petitioners who contend that the selections were vitiated by fraud.
Yes.
Right? You are in conflict with Mr. Dwivedi, are we right in making that assumption, right? They are the people who say that, look, we should have been selected.
That's-
You didn't select us, you selected other people by fraud or whatever. That's their case.
No, that has not been, sorry,
We are
that
not
has
making
been
any
not
observation
said
on
in the
merits. We are just
petition.
trying to understand the lay of the party so that then we can make bring
Right.
some order to the whole matter. Now, how many lawyers are in that category?
So far as.
We can't number them, most of us are in that.
All right, all right.
Just yet another category minutes.
So you would represent class 9, 10, 11, 12, group C and group D, right?
But
All right,
there are-
all right. Now, persons appointed whose appointments were cancelled. There we would have Mr. Vaidyanathan, Mr. Patwalia, Mr. Ramchandran.
So far as there are.
Well, there's also another subcategory. The subcategories of those people who are never parties in the litigation. And as a result of,
And whose appointments will be cancelled, right?
Yes.
Phillips, without being a party.
Right, fair. But whose appointments would be cancelled now? All right, all right. All right. RPI is also on the same, all right.
पूरा ऐसा मोटा चाप नहीं आ जाना
मतलब there are
चाप नहीं आ जाना
There would be categories concerning.
And persons who could be appointed and no action has been taken. Who are those people? Those are the people whom the government had said that all right, we'll extend some benefit to them, but eventually they were not appointed. So, one second, just 1 second. If everybody keeps on talking out of turn, we'll never be able to find chaos. Today, let's at least find some procedural formalities on this order. So we take it therefore that these are the 6 categories of people.
मतलब there are two more there are two more
There's
categories.
one more category. Matlab,
Which category?
there are two new diary numbers. We have filed yesterday.
Which category do you
This
belong?
category is, my lord, not called for verification, my lord. We were the original whistleblowers, my lord. Because of our original two writ petitions, my lord, a batch of writ petitions, my lord, there were CBI inquiries and there were certain orders.
Therefore, you want the process to be cancelled, right?
My lord, no, what we are asking for is, my lord, if the second limb of the judgment of the Honorable Division Bench holds good before this bench, that is to segregate, my lord, with regard to the people
Tainted
who
and the
are otherwise
untainted.
legitimate and got the jobs, and people who are not legitimate and but still got the job. My lord.
Now,
If
did
that
you get the
segregation-
job or did you not get the job?
Then, my lord, we will come into the, my lord, consideration, zone of consideration.
Oh, you will be the beneficiaries of segregation.
Yes.
Well,
That's
there is a,
really a
well, there is
subset.
another.
There are six, only rest are offshoot.
That's right. These six are the broad categories. Look, we are not going to shut out anybody who says in the hearing that, look, please give us 2 minutes. We'll also hear those categories. But broadly, these are the 6 categories. Now, 1 second. 1 second. Now, we are not going to add to the categories anymore. We're not adding to the categories anymore. Now, tell us, Asa Sharma will be the nodal counsel for the state of West Bengal. We'll
State.
also, for the state and the staffs and the school
State
selection.
commission and those other private whose examinations have been cancelled.
They all sail in the same boat.
Same board.
So on behalf of the private parties, is there any other nodal counsel whom we can appoint?
May I say one thing? When you're pointing
Sir,
out the category,
Same Gupta,
please keep it there, because within that category of people who have been today dislodged, there are subcategories.
Obviously.
You have the OMR sheets, you have
That's
the.
all right, but if we start Ms. Arora, if we start listing out all that today, we will be finding out now it will be like an argument today. We just want to give some procedural direction so that we will have one paper book common for everybody in this case. Otherwise, it will be impossible to sift through, 500 petitions.
But it will become extremely difficult for my lords to put all the categories into one.
No, we are not. We are not. We are just appointing counsel so that at least the relevant rules and regulations, precedents on which people want to rely upon, all that is at least compiled and put before us. The lead writ petition is put all that.
I have already filed my lord, honestly, admitted.
But that's a matter of argument.
Because the panel
That-
prior to the whole lot. It's all, we.
That's a
can
matter of argument.
Where?
Ms. Arora, if we don't do this exercise, it will be impossible to write a judgment, which we have 1,000 petitions or 500 petitions, and you have odd petitions, counsel telling us, well, this page in this petition, it's impossible to actually get down
I
to
understand that.
type a judgment. So we have to have some chaos in this, some order in the chaos rather.
Chaos
But there is a chaos, absolutely.
Let the school service commission do
Yes,
it.
just
All right.
Shalini called.
Because they are the central.
Sorry,
Shalini called.
all right. So we've got Asta Sharma,
Let's come and.
Shalini Kaul, and who else? All right.
For the in-service candidate.
In service.
In-service, my lord, who are working from 2007.
Asta Sharma and Shalini Kaul will be covering your perspectives as well as nodal counsel.
No, I didn't get your lordship.
We are just appointing nodal counsel as in the CB matters to prepare one consolidated finale.
We are looking for in-service candidates, and separate category altogether.
Everybody is in service.
2007, my lord.
Can I submit one thing?
You see, in-service candidates are exactly like Mr. Vaidyanathan, Mr. Raju Ramchandran, Mr. Patwalia, and Mr. Ranjit Kumar, whose appointments will be cancelled as a result of the judgment.
Can I just suggest, apart from these 6 categories, there are also 2 broad parallel categories in terms of the arguments. One will be 65B and the technical aspects, and the other will be the remaining. So these could be clubbed up together.
These are arguments. These are not categories.
Because that'll help this court. Ultimately,
You
it
are
will
saying
help.
that the 65B certificate is invalid. So that's an argument. That's an argument.
Lordship,
All right. And on this side, 1 second, please. Please don't talk out. 1 second. Don't talk out of turn.
Lordship,
Now,
similar matter.
don't talk out of turn. What applies to the left applies to the right as well. And to the center. Now tell us. Now I'll tell you what. Tell us now. On this side, is there any nodal counsel who would like to work with these 2 counsel we have nominated?
Because Shekhar Kumar would be there.
All right.
May I make one suggestion?
Mr. Shekhar Kumar? Right. All right.
One can have another.
Selected and.
Now, 1 second. In order to, no counter affidavit has been filed till date. Full stop. In the event that any of the respondents seek to file their counters, they shall do so on or before 2 saptah ka time de dijiye. If no counter is filed, the right to file a counter affidavit shall stand closed and the proceedings shall be conducted on the basis of the record as it stands. Next. Broadly speaking, it has emerged from the submissions of counsel on both sides that there are 6 that the categories in relation to the present batch of cases would comprise of the following. Bracket 1, the state government, the government of West Bengal, semicolon, bracket 2, the West Bengal Central School Service Commission, bracket 3, original petitioners before the High Court who are not selected, into brackets, representing classes 9 and 10, semicolon, 11 and 12, and groups C and D, bracket, and similarly situated persons. Bracket 4, persons whose appointments have been cancelled by the judgment of the High Court. 5, persons who would be appointed in pursuance of the decision of the in pursuance of the division bench, but where no action has been taken. Persons who would stand to persons who would stand to be appointed.
Persons will lose their job because of malpractice.
No, there is no direction. There is no category. There is no such directions.
Once, everything, right. Then that 5th category, then the 5th category we will not mention.
Blood direction.
And 5, one second, we are not putting the 5th category. 5, the Central Bureau of Investigation. Full stop. We have clarified during the course of the hearing to assuage the concerns of all the learned counsel that these are broad categories and will not exclude the possibility of any person having a distinct case presenting it before this court. Can you please allow me to argue, dictate the matter? Full stop. To facilitate, full stop. Given the large number of petitions which have been filed before this court, it would be necessary to have a common compilation which can be relied upon by all the learned counsel at the time of the hearing. Full stop. To facilitate this, uske pehle likh lijiye, during the course of the hearing, we have noticed that the court has been apprised of the fact that Mr. Rakesh Dwivedi, learned senior counsel, appears on behalf with Ms. Asa Sharma, appears on behalf of the state of West Bengal, while Mr. Jaideep Gupta, learned senior counsel, appears for the school service, West Bengal Central School Service Commission.
Mr. Kaul also appears.
Mr. Kaul, you are appearing for
the state of West
For the
Bengal.
state.
Okay, sir. Yes, you'll take that. The persons whose appointments would stand to be cancelled as a result of the impugned judgment of the division bench of the High Court are represented inter alia by Mr. C.S. Vaidyanathan, Mr. Raju Ramchandran, Mr. P.S. Patwalia, Ms. V. Mohana, Mr. Ranjit Kumar,
I will accept.
Ms. Meenakshi Arora, and Ms. Padmanabhan.
I am representing.
All right, so आपका भी नाम लिखो मिस्टर के
We are all representing our SLPs.
Must be your lordship have forgotten my surname.
You are away from Parliament today.
No, our Parliament is not there.
And Mr. Roy is for whom?
For the similarly circumstanced group D.
My lord,
Alphabetical order.
Lordship, I want to assist.
My lord, Mr.
Mr. Ranjit Kumar भी डाल.
Mr. Patik, sir.
Mati Diwan also.
Lordship,
Fair enough, Mr. Ranjit Kumar, Ms. Madhvi Dev.
Mr. Pratik,
See,
hai, my
we are
lord.
not, we are just putting out some names so that, we know when the matter opens up, who is appearing for whom. All right.
Lordship,
Lordship may not put any name, my lord.
All right,
Don't
किसी
put
का
any
नाम मत
name.
लिखो. All right, don't put any names because.
Otherwise there will be another chaos.
All right.
Lordship.
The ऐसा लिखते हैं हम, council appearing, all the council appearing in this batch of matters who fall into one of the above stated categories shall furnish details to Ms. Asta Sharma during the course of the day, so that a consolidated master list of council can be prepared. All right, then we will say in order to facilitate the preparation of a common compilation, we appoint the following, by consent, we appoint the following advocates as nodal counsel, : 1, Ms. Asta Sharma; 2, Ms. Shalini Kaul; and 3,
Kunal Chatterjee is there in all the matters.
Kunal Chatterjee is most important. He's for the board as well as for the school.
Kunal Chatterjee.
It's very important.
3, Mr. Kunal Chatterjee.
Because we are has been approved.
Yes.
Report from day one.
Right.
At our instance, Mr. Partho.
Mr. Kind,
We have
who? Mr. Partho Steel, the advocate on record. Thank you.
Mr. Partho.
Oh, Mr. Pathis, okay. All right. The 4 nodal council, that Shekhar Kumar we already put there. The 4 nodal council shall ensure that they sit together and prepare a common compilation in the electronic form. Full stop. This shall be circulated to all the learned council appearing on behalf of the contesting parties in the proceedings. Full stop. This exercise shall be completed within a period of 2 weeks. The proceedings shall be listed for final hearing on Tuesday. Place it exactly after 3 weeks. 2 weeks to file the counter. If no counter comes, and we're giving 2 weeks to prepare it.
Lordship,
Right.
Lordship, item number 26.
Right. The council falling in the above categories will be at liberty to file their written submissions, not exceeding 5 pages each. Not exceeding 5 pages each. Full stop. We would request all council appearing for a given category to prepare one set of submission. Right? So that, Mr. Batwalia, Mr. Ramchandra and Mohana, please sit down together and prepare one compilation. Your 5 can become 7, but, we'll then have some idea.
But Lordship, but my lord, for the writ petitioners before the High Court, they have to agree with all these arguments. Their argument cannot be with
One compilation means
one submission, one set of submission.
one type of sum, but
I think Mr. Gupta, Mr. Dwivedi, and Mr.
My
Anjumwal.
submission is just limited to 1 point.
So,
Rest all is
yeah,
Mr.
fair enough, but prepare one set of submission because you are the people who are challenging the judgment of the High Court.
Yes, madam.
Here the private party is challenging. The petitioners before the High Court are seeking to sustain the judgment of the High Court.
Yes, madam.
Get the broad categories now.
One risk.
And state and SSC, etc. is concerned, your lordships, because notice has not been issued in our SLP. Let them just circulate. We can apply to the registry and get their stand.
All right.
That is.
There are new matters today. New matters in this, kindly issue notice and direct.
All the matters.
Notice shall issue in all cases where notice has not been issued thus far. However, it is clarified that one counter affidavit alone will be filed in the lead matter. Full stop. Now, one more thing which I wanted to ask you was that we'll have only one counter affidavit. That's one thing is very clear. Now, apart from that, so far as the state of West Bengal, there are basically the most significant challenges are by the private parties who are going to be ousted, but more important, the state of West Bengal and the School Service Commission. Now, I would like to have, just so that we have some idea about the facts, can somebody take the burden of preparing a dispassionate set of list of dates containing everything?
That will
So, Dwivedi, will you be able to do that? Everything there. We don't be selective. We only request the state government can do that. Don't be selective in what you're disclosing. Put everything on the record because then it's a matter of argument. But otherwise, we'll not have a comprehensive set of dates. So please do that for us so that.
One risk.
Yes, their presence is very much required.
The board.
West Bengal Board of Secondary Education presence is very much required because there is an excess appointment. Full service commission.
The commission is the
No, we'll ask the state of West Bengal to do it. We'll coordinate with Mr. Dwivedi and both of you.
My lord would be kind enough, my lord, in the meantime, direct the CBI to place its report before the court. Let us know what has happened, how far they have proceeded.
Commission and the West Bengal
Board of Secondary Education.
Board of Secondary
Love to see.
One
That the board is very serious before the Supreme Court. And unfortunately, SSC, before this single judge, did not argue. Board did not argue. Board did not appear. Board did not argue. Nothing, no seriousness. We would love to see that they have become serious now.
Only 100 SLPs there, Milord. Certain SLPs are not appearing in your.
All right, now we'll get on with our, I think we brought some order to what we are going to do.
Milord, some of the SLPs
Milord,
are appearing in the.
I thought I missed it, Milord. Did this honorable court, Milord, direct the CBI to file its
All of them
report?
will be on board now.
Milord,
These are representative proceedings. I mean, it may at the end happen that some SLPs were not listed or whatever. They'll follow whatever you. When we have so many counsel across the spectrum making arguments, everybody.
Milord, one respectful sub.
All right, now.
Milord, one respect.
Liberty
All
to
good things
air
have to come
arts.
to an end. Vibha. All good things have to come to an end.
I have one request.
Malad CBI.
Milord, CBI report may be,
Important, Malad, in this regard.
already CBI has filed a charge sheet in this regard in all the four matters, RC 1, 2, 3, 4.
Malad, another thing is that Malad.
CBI has already filed
I
a
can't hear you at all. And we'll not be able to hear anybody because everybody's out talking out of turn. Now, though I don't use a hearing aid, we have switched off our ears to everybody in this matter. We'll hear it on the next.
That CBI has already filed a charge sheet in this regard. Let the report be filed on the next day.
Next. Item 14. Item 28.
Lordship, item number 26 is related. Okay. Good evening, everybody. It gives me. Hello. Good evening, everybody. I feel privileged to be here today
and speak with you about the AOR examination on advocacy and professional ethics, as you all know. I welcome you all, as I personally feel that you have chosen to write this exam, and perhaps many of you would know that I was also an advocate on record for almost 20 years. And it is only thereafter that I was designated as a senior advocate. But when we started our journey and also to write the exam, things were very different. Those were different times. But if you have to practice in Supreme Court, then according to me, to write this exam and become an advocate on record, in my opinion, is a must. You, after writing this exam, even now, you are all advocates. You will definitely join in the journey of developing the institution of the Supreme Court. And we all know how important it is and what role India and the Indian Supreme Court is playing in the world. I am a first generation lawyer, and I feel I am very fortunate also to have entered this profession. How the lawyers should conduct themselves basically is the theme of this paper. In my opinion, I will first talk on what is that an advocate, a successful advocate, needs to do, or how he should carry himself. Ethics, according to me, professional ethics are basically is living by your conscience. In my opinion, ethics is nothing but living by your conscience. It is also very important, at the outset, I want to also mention that although this paper of ethics may seem something to do with which we daily do not in our professional career come across the rules and regulations which are enshrined in various statutes and rules, and we don't pay too much attention during the course of our practice, but we all know the importance of these rules, regulations, as how we conduct ourselves in the profession is of utmost importance. Now, we all have joined this profession and we all want to grow in the profession. But according to me, simply growing in the profession or having more wherewithal or having more materialistic things may be known as that it's a growth. You have grown in the profession. But according to me, growth without ethics, and ethics which is discipline and honesty and following the norms, can only mean progress. So if you want to progress, growth must be coupled with ethics. And then growth plus ethics, which is equal to progress. And progress, according to me, is something which you all achieve success, through which you achieve success, comes when you develop morality, spirituality, and humanity. That is how you achieve the whole success. Now, one very important feature right in the beginning of your career is that actually today we are in a race. But let me tell you quite clearly that this race that you have begun is like a marathon. It is not a sprint. It is not a 100 meters race which you can get over in a few seconds. It's like a marathon and will continue probably for the rest of your career. One of the most important things for advocates is that throughout your career, as I said, you have to live by your conscience. You are your own judge. Of course, there are people who are judging you all around, but the most important burden that is cast on is you yourself. Now, if you look around you, people have different opinions about lawyers, whether lawyers exploit clients or clients exploit lawyers. These are all, things which you will come across. But once you are steady and you have your feet on the ground, it is absolutely clear that you will sail through quite easily. I also feel that at the outset, I should bring to your notice a few lines from some very important judgments, which will bring out clearly as to what is the purpose of ethics and how you should conduct yourself in this noble profession. Therefore, please allow me at the outset to also quote from a judgment of the Supreme Court which was delivered in 1979 in the case of V.C. Rangadurai versus D. Gopalan, in which Justice Krishna Iyer, who doesn't know Justice Krishna Iyer, in his beautiful style that he had, how he had, in a very short passage, described our profession and what we should be doing while we go through it. Let me quote from para 5 of his judgment in this case. Law's nobility as a profession lasts only so long as the members maintain their commitment to integrity and service to the community. Indeed, the monopoly conferred on the legal profession by the Parliament is coupled with a responsibility towards the people, especially the poor. Viewed from this angle, every delinquent who deceives his common client deserves to be frowned upon. how beautifully Justice Krishna Iyer, in this small passage, has described our profession and how the members of our profession have to carry out their duties. Yet in another matter, namely Pandurang Dattaraya versus Bar Council of Maharashtra, which is a case reported in 1984, the Supreme Court has held, and I quote, an advocate stands in a loco parentis towards the litigants. Therefore, he is expected to follow norms of professional ethics and try to protect the interests of his clients in relation to whom he occupies a position of trust. Now, you must have followed this carefully and kindly appreciate that there are two very important things which have been said in this paragraph by the Honorable Supreme Court. That an advocate stands in the position of a loco parentis, which I don't have to describe to you, but you will all understand the meaning of it. And therefore is expected to follow the norms of professional ethics. And also he explains that the relationship between you and your client is that of a trust which you have to carry out. One more last quotation from the Supreme Court, which I would like to mention here, was in the case of Bar Council of Maharashtra versus D.V. Dabolkar. It is a bench of 7 honorable judges. And Justice Krishna Iyer again, in his inimitable style, mentions, and I quote, the bar is not a private guild like that of a bakers, butchers, and candlestick makers, but by a bold contrast, a public institution committed to public justice and a pro bono publico service. The grant of a monopoly license to practice law is based on 3 assumptions. And I thought this is the entire gist of what we are talking today. And what are those 3 assumptions that he mentions? Let me bring them to your notice one by one. The first is there is a socially useful function for a lawyer to perform. So the work that you are doing is very much connected with the society and how the society grows, how you have to become socially useful. The second assumption quoted in the judgment is that the lawyer is a professional person who will perform that function. And third, very importantly, it is mentioned that the lawyer's performance as a professional person is regulated by himself, not more formally by the profession as a whole. The central function is nothing less than the administration of justice. Therefore, your duty, there is a lot of burden which you will carry on your shoulders as a lawyer. It is not simply a profession to earn money or to quickly earn money, as these days we find everybody is very keen to quickly earn money. And even when they look at some of the lawyers who are doing very well in the court, they assume that these lawyers probably landed up in the Supreme Court and they were doing as well as they are doing today. They forget that even lawyers like Ram Jethmalani, Fali Nariman, Soli Sorabji spent number of years in the high courts and in trial courts where they practiced day in and day out. And it is only thereafter that they could step into the Supreme Court. In fact, I would like to mention to you that when I joined the Supreme Court in the year 1975, for the first time, the 4-year rule was introduced for giving the examination. We were all very upset because before that, you could write the exam after 1 year of training with an advocate on record. And we made a lot of hue and cry, etc. But we were informed that the then Chief Justice was determined that if we make, if we are not happy with it, we were communicated that he was going to increase the period by 7 years. So we all backed out and waited for 4 years and did our practice and then wrote our exam after that rule was introduced. And today, I think it was a beneficial rule. It gave us chance to learn, to practice what was written in the Supreme Court rules, what was in the Bar Council of India rules. As I told you, the moment you start your practice, things were at that time very different. We paid very little attention to these rules. Even today, I know that these rules are somehow not that favorite of everybody, but they play a very important role in your life. And as I said earlier, every advocate has to live by his conscience, and you are a judge of yourself. Now, the Bar Council of India has framed several rules which you must have gone through. Of course, one of the foremost things that comes to my mind is that we all learn that today, because of the changing world and growth of technology, we have the assistance of laptops, we have assistance of internet, but still our rules which are provided in the Bar Council are very categorical and clear that you will not solicit. You cannot advertise directly or indirectly. And you are aware of the fact that they've given a certain manner in which you can even have a website, but you have to get it approved from the Bar Council and you have to adhere to the rules, the circulars regarding advertisement, communication, interviews, etc. So one very important feature that is regulating the lawyers is the Bar Council of India rules, which form the basis of how you have to conduct yourself as an advocate. We are very much aware of the fact that there has been an issue which has been lingering on in our profession for a very long time, which relates to strike by advocates. There are a number of cases which are decided by the Supreme Court because the problem has grown and it has happened repeatedly. And through these judgments, you have learned and you have to follow them. And what they really entail is that your rights end where the litigant's rights begin. So it is not only your rights which you are agitating by going on strike, which are important, but you cannot forget that once you file a wakalatnama, you are representing a client. And our system basically is meant for litigants. The Supreme Court or the High Courts or the trial courts, the judges, the staff, and the advocates, they are all there to assist the litigants in getting justice. So you have a duty and an obligation, in fact. Therefore, any unethical and unprofessional act on your part is not going to be successful, because administration of justice cannot be infringed. And you are a part of that. As I explained earlier also, that your role is basically in running of the administration of justice. It is not only the judges and the registry and the staff which carry out their duties from day to day. You have to perform a very essential part of your duty, which is to get justice delivered to your client by assisting the courts. There are only few exceptions, though. There are exceptions, and very intelligently, the courts have understood it very well. In rare of rarest cases, as you know, where dignity of the bar and integrity of the profession is involved, they have carved out exceptions. They have even prescribed a period, because lawyers' voice in the society carries a lot of weight, and democracy it's very essential for democracy that we have independence of judiciary. In fact, you are all helping the administration of justice, and whenever there is an event which strikes on the independence of judiciary, which is a rare of rarest case, and the dignity of the bar or integrity, then the courts have made an exception. The other important thing which I want to bring to your notice is that professional misconduct sometimes may also give rise to contempt of court. The Contempt of Court Act and the Supreme Court under Article 129 and also the Supreme Court under Article 142 have vast powers. In fact, there is a very famous case, a celebrated case, which I don't think I need to mention, but you are all aware, where a lawyer was found guilty of criminal contempt because of his behavior in the court, which was in the High Court. The Supreme Court took up the matter by invoking its powers under Article 129 of the Constitution, read with Article 142 of the Constitution. Supreme Court categorically held that if there is a contempt in the face of the court, the Supreme Court has the power to protect the High Court from such a behavior. But we also have to keep in mind that in the Contempt of Court Act itself, fair and accurate reporting judicial proceedings will not be contempt. Fair criticism of judicial acts are not contempt. But again, as I said, it cannot be taken lightly. A lot of duty is cast on your shoulders. In fact, I am aware of a case where sometimes, and as I said, in this particular case, when I was in the court, the lawyer was very vehemently, aggressively arguing his case. And the court, after some time listening to him, said, there is no problem, you can go on. Because it is your duty. But if you perform it within the Lakshman Rekha that is provided, we will only be assisted by you. There is also something very important which you all know, and which is the privilege that we advocates have with regard to the communication with your clients. Now just see how carefully that law has been made so that you and your clients can freely discuss the problems. The Evidence Act, as you know, provides that exception. But again, it is not an exception which will last forever. You have to be careful. As I said, your conscience should prevail in every difficult situation. And since you are taken upon the task of becoming advocates on record of the Supreme Court, it is a fact that you are not different from other advocates. But to assist the Supreme Court in discharge of its working, in delivering justice, your role is going to be very, very important. In fact, the courts are dependent on you. And I remember once basically I had committed I need not go into detail. And inform the court that I was wrong in what has happened. The Honorable Court mentioned that since you are not a fly-by-night lawyer, and we know that you are devoted to this profession, that mistake was rectified by the court. I was mentioning the privileges. Just like the privileges that you have, which have been enshrined in a statute, there are also your duties. And as I mentioned earlier, your duties towards your client, towards the court, are clearly mentioned in the Bar Council of India rules. Please go through the same. And remember, it is not just for this exam that you are giving. It is something that you have to carry with you in your mind all the time. Because once you are a lawyer, it is not as if you are going to practice for a few days. In fact, there is no retirement age also. So it is also said that advocates are a very important part of the society, because the way you conduct yourself in the profession becomes your habit. And even if you are not a judge in the court, you are always providing solutions to your friends, to your neighbors, and society at large. And therefore, they all look up to you. And that is how you have to carry yourself. So your duties towards the client and the court, please go through them carefully. It is another thing that which is very disturbing in our profession, which we all encounter. And that is the menace of some third parties who try to take advantage of our profession. And the rules categorically point out that if there are people who are not advocates and are trying to procure advocates by taking remuneration from clients, they have to be castigated as touts. You will find this menace and you have to deal with it. You have to overcome this problem as an officer of the court who is representing the clients who are in need of justice. I think I am not going to bring out each and every rule of the statute or the Supreme Court rules, which you can read yourself. But my purpose was to give you an overview of how you have to now conduct yourself. It's not only after this exam, but earlier also, before the exam also, you have been under training and you must have gone through sleepless nights because this profession is a very demanding profession. It is easy, somehow relatively easy to enter the profession, but it is only your hard work with a lot of courage, grit and will, and following the rules and regulations that will bring success to you. So good luck to all of you. I think I don't want to say anything more at the moment. I think Kiranji is there now. Kiranji will take it further. Kiranji, over to you.
Thank you, sir. Mr. Datta has very eloquently pointed out what are the misconducts, professional misconduct, contempt of court act, strike, evidence act. So I'll not deal with that. Firstly, good evening to all of you. This is a paper, Advocacy and Professional Ethics. I'm sure all of you are looking for some hints. I'm not sure whether I'm going to give it or not. You have to catch it. It will be there in the lecture. You'll have to catch it. I will have my lecture in 5 sections. First, I'll tell what is the need of this paper. What is the importance? The second will be advocacy with reference to your duty towards the client. Third will be professional ethics with reference to your duties towards your client, court, opponent, colleagues, etc. Fourthly, special status which AOR have got in the Supreme Court. And lastly, our most celebrated 7 lamps of advocacy. The first is, what is the importance of this paper? I think this is the most important paper in the AOR exam. at the early stage of your life in the profession, you are reading Advocates Act, you are reading Bar Council of India rules to know what is misconduct, which you should not follow. What are the possible punishments? What are the possible defenses? You are also made to see Contempt of Court Act, that what type of conduct can amount to contempt of court, which you should avoid always. Then you have Evidence Act, which talks about confidentiality of the information given by your client, which you go through and you use it for whole of your life. And above all, you get into some professional dilemmas in your life, in the professional life, and this paper helps you to take the right decisions. The moment some professional dilemma comes, then you start thinking, yes, this is the ethic. I must follow it, and you take the right decisions. Other three papers may change, but basic duties of advocates in this profession and professional ethics and advocacy, that will not change. We may change the system. We may go to website, we may go to Instagram or Facebook, but our basic duties towards certain people will remain. And you will have only limited scope of publicizing. That's the importance of this paper, which will help you not only to become a good lawyer, but also to become a good person, for the reason that you are spending almost 12 to 15 hours in a day in this profession. If for 12 to 15 hours you are following ethics, you are bound to become a good person as well. So keep in mind the importance of this paper. Now I'll come to advocacy. My colleague has, Mr. Datta has already dealt with that you will have professional misconduct, etc. Now your duty starts the moment client approaches you. When your client approaches you, so you are at the SLP stage. Once it is SLP stage, at that point of time, you will have pleading. You will have documents, you will have evidence. You will also have the 2 or 3 judgments in your hand. You have to carefully go through the entire paper, all the papers, to come to the point how you can say that the impugned judgment is not correct. We have seen in the courts many a time judges asking that you say this is not correctly written in the impugned judgment, but have you taken this ground? If you have not taken, mostly you're out. Otherwise, maybe some liberty is given to file a review petition. But these are very important things. So you'll have to go through all the papers before drafting the SLP. I can't tell you about the drafting. That drafting persons will tell you. So far as advocacy is concerned, I will only tell that your synopsis, list of dates should be precise so that you can save the time of judicial time. There are 3 fundamental qualities which the client is looking from you. One is your utmost honesty. Secondly, your integrity. Thirdly, your diligence, which includes dedication and competence. Honesty, you're all aware, you have to be honest to your client. You have to tell everything, whatever you think is possible or not possible, so the client can take informed decision what he wants to do. Integrity is very important because we hear the sometimes instances where the advocate has not come up to the mark because he did not pursue the matter because of some extraneous circumstances, extraneous reasons. So integrity is very important for the client. And the third is diligence, that is your competence. It's not that when we get a case, we know everything about the case or the law. But we keep in mind that when you are filing SLP, you have to do sufficient research that sufficient research can make you competent enough for that particular subject. And the moment you have that subject, get that competence, definitely you are going to, you are bound to get some good audience, if not relief. So I will give you one or two examples. Like initially, when you file a suit for specific performance, somebody filed a suit for about 20 pages. And what was missing in that was readiness and willingness. We lost the case only on that count. So that these are small things which are not, which you could have known had you done enough research before filing of the case or before filing of SLP. At the same time, don't say no to a case because we are not judges. We are advocates. I remember an instance where, as the early stage of my career, thinking that I'm a very honest person, I told the client and advised him not to file SLP because there is nothing in your case. Client went off and somebody else filed the SLP. Notice was issued, stay was granted. So we cannot be the judges. So you don't know because every day we face surprises in the court. Then one instance case I really remember, it was a landlord-tenant case. I was appearing for the tenant for the petitioner. And that was the time when the court was looking at that if I have to give you 6 months time, I have to issue notice to the other side. I requested that you give me 6 months time. And he said, but I have to issue notice to the other side. I said, it's fine. Notice can be restricted to that. Notice was issued, restricted to whether 6 months time should be granted or not granted. And ultimately that case came up before the court after 7 years. We had nothing else but to smile. So you never know because court has taken us by surprises many of them, therefore don't take a decision. That is one part of advocacy. The second part of advocacy, because many a times you don't get these second type in the books. You get it and learn it by observing, listening, and appearing in the courts. The first and foremost thing is that you should know your facts well. If you don't know law well, it can be still pardoned. And the court can give you time that look at the law and come back. But if you are not good at your facts, then probably you are not doing justice to your client and failing in your duty towards your client. Therefore, that is the first thing. Secondly, keep in mind that you are assisting the court in imparting justice. So your narration has to be accurate as far as possible. Thirdly, you have to keep in mind that when you're citing a case, you should not go only with the head notes. You read the head note and go and cite a case because head notes are many a times deceptive. Secondly, they are part of the paragraph. And if you see the entire paragraph, you will find that ultimately the case is against you. And sometimes you find in the court, judge is saying that this case is against you, you're citing it. One aspect you should always keep in mind is when the court has put a query to you, answer that query. Because if you don't answer that query, you're not going to get relief. Ultimately, judge is going to give relief. So you must answer that query as far as possible to the best of your ability. And then we always have but. So, but for some reason, we always explain later, but queries should be answered. That is the advocacy which you see in the court every now and then. It does not mean that you should not assert. You must assert. Be confident, argue with tenacity, so that you are doing complete justice to your client. And when I remember once Mr. Nariman saying that the best of the arguments we find is when after losing a case, we come out of the court. So assert as much as you can, be persuasive, because ultimately we are assisting the court to the administration of justice. So advocacy, firstly, the drafting part, getting information, getting yourself educated, then drafting, then appearance in the court. And also keep in mind that you have to do, your conduct has to be such that it doesn't put you to trouble. I know some case, somebody, I'm talking about earlier when I was not designated, somebody approached me to file a case in the consumer court. Then I said, fine. Then he asked me how much fees, court fees we have to pay. I said, consumer court, there is no court fee. He said, but when we came in the first round, we had paid about 2 lakhs court fee. Now I'm in a dilemma. There is some Milan Kumar. There is some this thing that Milan Kumar, please mute. So therefore, that is not even the misconduct. It is you are cheating the client. Now I had a dilemma whether I should expose that advocate who has taken 2 lakhs of rupees for the consumer court or not. Professional ethics, honesty, everything comes to my mind. But then I kept quiet. It was wrong, but then I did it. When I say, that's why I say, when you are dealing with this paper, you will find several occasions in your life when you will be debating between yourself what you are going to do. Now, next section, which I said, is the professional ethics. Professional ethics comes to you even before the client approaches you. Advocacy starts when the client approaches you, but professional ethics start even before they approach you. The first principle that you cannot advertise or solicit is before anybody is approaching you. We all know what is the advertisement, so it will be very, it will not be very difficult for anybody to understand that. But soliciting is one area which is little which is debatable. In today's world, when we have website, we have Instagram, etc., we know many of the websites are having some information which they are not supposed to give. We are all keeping quiet. Bar Council, who is supposed to take suo motu action, is keeping quiet. Advocates are not bothered. I remember an instance which, of course, I would like to share with you. I was sitting in the court, a case of a very, it's a big case, and association, some senior advocate was sitting with me. He asked me a question. He said, which senior is appearing for you in this case? I told him my client has instructed not to engage any senior. Then he tells me, okay, please tell your client that I am ready to appear free for him. According to me, it's soliciting. But then my dilemma started. Whether should I tell it to my client or not tell it to my client? Or think it is a soliciting, I should avoid it. But then, being honest person, I thought better tell to the client, let him take a decision. So I told the client that like this senior has told me that in case you approach him, he is going to do this case free for you. Client agreed straight away. Yes, let him do free. He is doing free. Why should I not avail his services? And we went to that senior's office and gave him the file, etc. After a couple of days, I was not there in the case. there was somebody else from their office who was in the case. Then again, dilemma came whether I should disclose it to somebody or not disclose it to somebody. I should file a complaint or not file a complaint. But I left it because it was word versus word. If it would have been definitely, I would have made a complaint. So therefore, soliciting is one area which comes to us even before the client approaches us. That's our duty, that we should avoid any such soliciting. Now, writing letters to the prospective clients. Today, what's up to the prospective clients definitely is soliciting. But everybody is keeping quiet. I have hardly seen a case in which misconduct on the basis of soliciting has been punished or reported or punished. That is before. Now, next stage comes when client approaches you, but he has not hired you. When he comes to you, you're bound to accept his case. That's your duty. But at the same time, you are supposed to reject his case if he insists upon illegal means. Now your duty starts whether you should morally or legally accept the case or not. Because after hearing the client, you may find that there is some conflict of interest. Therefore, you cannot appear. But by that time, that client has already disclosed his confidential information to you. You have to maintain that, so you are blocked. You cannot appear for the other side because confidential information to you. Now, I remember a case in which one advocate, his uncle was a attesting witness to a will. He doesn't know because he came to profession much later. And the other side approached him, he filed the case and he was continuing with the case. Suddenly one day, the other side files an application that he is likely witness in the case because his uncle is dead and he's the only one who can identify the signatures. He has accepted the brief, he's continuing with the brief, but he's in a dilemma, what should I do? So you have to decide according to your conscience at that point of time. He decided to continue. He said, you can't block me like this. But that's his conscience. I would have left it. So therefore, these all are happening before even you are hired. Now, at that point of time, it is your duty to give fair advice. Fair advice is sometimes you should file SLP or not file SLP is not that you can always do because you don't know what's going to happen in the court. But like I said, taking court fee for the consumer case and asking them to file SLP against a review order which is not maintainable. These are the things which you should never do because this reflects your conduct. I remember a case in which one advocate who was standing outside the court, his case was being called inside, and ultimately on the second call, it was dismissed for non-prosecution. By chance, I knew the advocate. I thought when I came out, I told him, oh, your case is dismissed for non-prosecution. And I was surprised. He told me, I got it dismissed for non-prosecution because client has given me a meager fees. Now it is dismissed for non-prosecution. He will contact me. I'll get my balance of fees and make an application. Method. We are all innovative. Advocates are very innovative to find their ways. But at the same time, our duties. Whether he has not complied with any of the duty, or it's only a method he has used. Decide. Now you have a next comes is you are hired. Now you are a duty to get the brief, unless there are special reason not to accept it. Then your duty towards court also starts. You have to maintain the status of dignity and decorum of the court. You have to act in a dignified manner, utmost respect to the court, duty to assist the court by doing a proper research. But when you are appearing in the court, many times you will find that judge is not in your favor. No problem. And that is the time when your patience are tested. Your duties are tested towards the courts are tested. The court is against you. At that point of time, your behavior should be dignified, not only in your express words, but also in your conduct. Because the other day I was sitting in the court, somebody was losing the case, court was against him, and instead of saying anything, he made some gestures which court did not like. So your body language, even when it is against you, should not reflect any disrespectful to the court. That is your duty, because ultimately court is not stopping you from performing for your client. Your utmost duty towards client remains. But they are only saying, be respectful. They have taken a view, right or wrong. That's not your business, because they have to impart the justice. Now, there are other duties of the advocates. I find now over the years, some of the traditions which we have been following are getting diminished. Number one, I find that when junior advocate comes to the court, asks for a passover, and he states, my senior is appearing in chief's court. Court asked, chief means what? Chief of Gunda, chief of gang, or what? You should say the Honorable Chief Justice of India. And our juniors using word yeah, I think we all have heard it. There was a time when even in the court, I remember Justice Kripal's court, one advocate was sitting with his body laid back, and Chief Justice Kripal told him that, look, you are not sitting in your drawing room, you are sitting in my court. Sit properly. So therefore, in the court premises, when we are all failing because we are not able to mentor our junior colleagues. One of the advocate they come for passover, they don't even know they are appearing for petitioner or respondent. Only thing they know is their senior's name is this, and therefore they need a passover. They hardly know what is the case, whether it's a civil case or a criminal case. Many of them, not all. So therefore, these are the things which we must mentor to our juniors. And one more disturbing factor which we find in the court is find that on last two seats, only interns and junior advocates are sitting. They are no problem in that. Most of them are concerned only with their mobiles, whether they are looking at social media or whether looking at a chat or whatever they are doing. They are pretending that they have not seen many seniors sitting around. So many seniors standing around. We had a tradition because we treat it as a family that, okay, we'll give a seat to a senior. And that type of professional ethic, rather, we can say, which traditionally we followed and which is not there in Bar Council of India rules. I think we should continue. However big you may become, you have to follow the whatever law is. when you are looking at your mobile and not listening to the arguments or observing in the court, you have closed your one method of learning. And that's a very, very good method of learning. Now, you are all appearing for your exam. I'll be saying all the best to you later. But at the moment, I want to point out that Supreme Court as an institution has got great confidence on the AOR system. They want AOR examination to continue. You have higher responsibilities than other advocates. You are the link because you are supposed to have registered clerk, office within 16 kilometers, etc. Because you are the link between the client and the court, or client and the senior, client and the other opponent also. Therefore, it is very important for you to understand and realize your duties as advocate on record. Keep in mind that merely by signing the SLP papers, even for a friend, may land you in trouble. If you are signing, no idea, we also have